Well, hi there, good afternoon, Alex Wood, civil litigator here. This is a YouTube channel to help people run their own claims in the small claims track or even the fast track and help them get to grips with understanding the county court system in the UK courts. Now, here is a vlog on the topic of the reply and the defence of the counterclaim. Okay. Now, the very first thing to say is this is not how to draft a defence. I've done another vlog on how to draft a defence, but it is very similar. And it is quite a common situation, I've discovered. And this situation often arises, and I'm dealing with a small claim here, where a claimant here we have his claim form, has instructed us from some legal advice because things have got a little bit tricky and turbulent with his case, where you've got a relatively straightforward claim form which says we quoted for supply and fit of a boiler system, we completed the work as agreed in accordance with our quotation, blah 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 blah. The invoices are now outstanding. The claim value here is approximately £2,500. And as far as he's concerned, our client, the boiler man, has fitted a boiler in a flat in London and he wants to be paid. Now, unfortunately, what can often then happen is he's stepped on a mine. There's a whole load of reasons why the defendant, in this instance a lady, is unhappy. Here is a sheet of this is her defence, and there's another sheet there, so she's been pretty comprehensive in laying out why it is that she says not only should she not be paying his invoices for the initial work, for the work for fitting the boiler, the new boiler, but more significantly perhaps, as I say, this does happen quite often, she's claiming over £4,500 that are damages that she said has been caused by his incompetence. Okay, so what I'm going to do here is just show you, well, I should just probably first show you that this was his response. I may put it up on the screen. This is his defence and the reply, in defence to counterclaim that he drafted, because I don't want to do too much work for people. I want to sort of hold their hands, give them advice, but not get involved in conducting litigation. That's part of the small claims service. So down to the drafting, which is what this vlog is all about. Okay, so here you've got the various points that she's made in her defence. We'll come on to her counterclaim in a moment. All right, now I'm just going to deal with the first 3 or so points in her defence and show you how to deal with allegations that are made in a defence with which you entirely disagree. Okay, now I think the very first thing to say, I've said before, is this is a statement of part of your statement of case. It's the pleadings. It's not evidence. Okay, so don't be throwing in the kitchen sink with your reply and your defence to a counterclaim, just as you wouldn't be with the claim or a defence. Okay, so evidence comes later. Look at the vlog on how to draft a witness statement, which is the way that evidence is produced at court. Okay, by means of a witness statement. This isn't evidence. This is just telling the story in a clinical, kind of matter-of-fact, logical, chronological way. So, as I say, keep it short, simple and pithy and deal with the allegations one by one. Okay, so having now had a look at the defence, we now see the reply and the defence to counterclaim. Okay, the first thing to note is that it's perfectly acceptable and maybe quite important for you to just throw in an introductory paragraph that sets the scene. Now, in this instance, you can see that the issue is you've got the sort of, what's the word, the alarm bells are ringing, because she's mentioned things like gas safety officers and the national grid saying the boiler's not fit for use and da-di-da-di-da-di-da-da. Clearly, a judge getting hold of that is going to think, oh, and apparently there's a gas safety officer's report that says it's not to current standard. So, you know, these are clearly issues that need to be addressed and need to be addressed in detail. But perhaps the first thing to do is simply to set the scene. So we do it with this particular opening paragraph, if you like, you know, which really explains in summary form the crux of the issue. And I mean, I'd recommend that you do the introductory paragraph last, because it's kind of summarising everything that's going into your reply and your defence to counterclaim. And although a reply is not often necessary, where you've got a defence and a counterclaim that's really making this a much bigger case, and there are accusations of breach of contract, kind of negligence here, and failure to meet health and safety standards, you know, where you're dealing with a case like that, then you use the reply as an opportunity, if you like, to beef up your claim. All right. Whereas normally, if you're already bringing a long claim and you know it's going to be defended and denied, you know, then you put all this information into your claim. But where this is the peculiar thing of often that you find about a defence and a counterclaim is that where it's unexpected for an unpaid invoice, that, you know, you've then got to, in a way, put in a reply, and perhaps put more in a reply than you would otherwise. So, you know, essentially his response is, you kicked me off site before the boiler was operational. In fact, it was very close to being operational. You kicked me off site, for reasons we'll come on to, and then you get in the National Grid and the gas safety officer. Of course they're going to find that the thing is not ready to use and not up to current standards, because I wasn't able to do the snagging and finalising and making it operational stage on the boiler. We then come on to the various points that need to be covered off, and you can see that the thing about pleadings is that, you know, you've got to take each of your opponent's allegations and address it. Not get too emotional about it, but simply address it. So, you know, in paragraph 2 here, we have, you know, this issue of the fact that there wasn't an accredited gas safety engineer on site. Well, that's hot air in this case, because he doesn't have to be on site all the time. He just needs to be there to perhaps to clear off the job. Nevertheless, he was there all the time, and it's particularly important for him to note in this case that the reason he's not in the records of the management service company, because I mean, perhaps you're meant to technically sign a bit of paper every time you come on site. You can see how that doesn't always happen. You know, building workers, they don't sign a bit of paper every morning when they come in to do a job. Or perhaps, as in the case of this client, he's been in the block previously to do other people's boilers. So it's important that you knock your opponent's allegations on the head. Don't get too emotional in what you're saying. Try and keep it short and succinct. So number 3, well, here we go into more detail as to why it was that, you know, the boiler wasn't operational and the National Grid labelled it as do not use. Again, there was a dispute. It clearly looks to me as if the defendant in this case has been quoted. She's tried or expected that that's going to be it. The claimant has said, the boiler man has said, well, look, you know, I can't completely rule out additional extra work. This is such a commonplace issue, isn't it, with tradesmen? I may have to, you know, I don't know what I'm going to see once I've dismantled the boiler and you know, and seeing if there's any extra work required. In this case, there was a load of extra work required that he didn't actually invoice for, but those parts of work that were absolutely essential and that he wasn't actually prepared to pay for out of his own pocket were a timer and specifically a zone valve. Number 5, again, it's always sort of useful to use pleadings to bolster your own case and to lay down the facts as you see them. And in this instance, he's making the point that, I did a whole lot of extra work, well over and above what we'd originally quoted because of the unexpectedness of the job. In this case, the boiler and the flue were particularly unusual and particularly problematic. And yet he's not added to his invoice an account of the extra work that was incurred. I can go on and on and on and on. I'll stop there because what I'm going to do is jump to the defence and the counterclaim. So once you've dealt with those specific items in the defendant's case, just bring it up here again. She's then making a big beef of the counterclaim. All right. Well, the thing about counterclaims, she's not only making a beef about damage or loss that was caused to her, but she's also saying that she's not going to pay for these additional items of the timer and the electrician's work and the zone valve. Okay. I mean, kind of ultimately relatively minor issues, of course, but unfortunately these things snowball and escalate. Anyway, when it comes to the defence to the counterclaim, okay, the big issue here is defendants, as you see this time and time again, often try and over-egg and beef up some massive loss to them that they imagine and often greatly exaggerate. And I think this is what has happened in this case. The fact is, as of today, as we mentioned in the opening paragraph, this boiler is in fact fully operational to current standards. Since the dispute first arose, he has been back to finish off, she's let him back in to finish off these snagging items triggered by the gas safety officer's report. All right, so it's now a complete job. Nevertheless, there's apparently £4.5 grand worth of losses. So the important thing here is to, deal with this in tough language. She should provide detailed breakdown of those losses, and if not, the judge is only going to kick it out. In fact, the claimant here could apply to have that part of the defence struck out if it's totally fanciful and opportunistic. And I wonder whether or not it might not be opportunistic here. And clearly he fitted this boiler. She was unhappy with the look of the interior of the kitchen after it had been fitted. He says because of the fact it was slightly larger, the existing infrastructure was partly rotten and had to be removed. And I guess there's an opportunity. She may have spent money, she may not. The interesting point here is that the company who did the remedial works is probably her own father's building company, which again is we've made sure to mention in this defence and counterclaim. So when dealing with that counterclaim, you'll often find yourself strenuously denying it, and this is, as I said, the important thing is to require the defendant to particularise her loss, to detail that loss. I mean, not necessarily just the amounts, but, well, what was it? Was it a carpentry? Was it a new expensive door? Was it damage caused to a beautifully tiled floor? If so, provide the invoice for the repair. All these sorts of things should be provided by the defendant, and they should be particularised in this counterclaim, and they're not really particularised. Remember, we're not expecting to see we're not expecting to see evidence from her of the works necessarily, but at the very least you're expecting to see her specify the items of damage themselves. The more detail the better, as well as the individual values. But invoices from the actual tile repair service or whatever the carpenter to deal with damage that was done to the room, they will be produced later on by means of your witness statement. So you don't provide that documentation in your pleadings. So there it is. That's your defence reply to the defence and your defence to the counterclaim. A defence is just, a counterclaim is just like an ordinary claim. It requires a defence. A counterclaim here is that there was damage caused whilst he was fitting a boiler. Finally is the statement of truth. Don't forget, obviously, that you need to date your pleadings, and you need to swear that they're accurate at the bottom. So there it is. That's your defence to a counterclaim, and as I say, in this instance, quite a lengthy reply as well. Okay, well, I hope that assists, and I will finally emphasise the importance of keeping your pleadings, whether it's the claim, whether it's a reply, whether it's defence, whether it's counterclaim, whether it's defence to a counterclaim, to keeping these pleadings accurate and very factual, chronological, telling the story, but not going on about the evidence, okay? And in the case of this reply and defence to counterclaim, addressing after the introduction step by step, and whether you, as a lawyer, the approach you take is, do you agree with what's being said, do you deny what's being said, or are you kind of neutral and no comment about what's being said? In this instance, he's pretty much denying everything that is being said. All right, hope that's been of use. Bye for now.